In October 2022, the lender advanced to the borrower a mortgage loan in the amount of $760,000 with interest at prime minus 0.28. The term of the loan was for 5 years, so maturity is in November 2027. Defaults under this mortgage occurred in July of 2024 when the monthly payment wasn't made, and this payment default continued thereafter. In addition, a tax certificate shows that realty taxes for the property are in arrears over $12,800, and this is for arrears going back to 2022. This constitutes additional defaults under this mortgage. Given these defaults, demand was made in October 2024, and despite this demand, no amounts were received. A notice of sale for the property was issued and served in December of last year. In terms of the accounting of the mortgage balance, the breakdown of charges we are seeking can be found in an Excel document that we uploaded to Case Center, and it shows the amounts owing.
Yeah, just slow down. I'm going to put that in front of me.
Master A105.
1-3. All right, then the number again,
A105.
Okay, thank you. Okay, I have it.
Yes. And so these are the amounts owing as of today's date based on the per diem in the affidavit. So as Your Honor can see, there is principal and interest. And in addition, there is a charge for cashback recovery. When the defendant obtained the mortgage, she received a cashback payment in the amount of $3,100. And so given default occurred prior to maturity, a prorated portion of the amount is repayable, and that is the $1,800 charge. And lastly is the property management charge. This is for one occupancy check that was completed for the property. So those are the charges that comprise the full balance.
I was curious about that. Okay.
This is a straightforward matter. The position of my client has been to enforce its rights under the mortgage and has consistently acted within its rights. The defendant has had ample time to rectify the indebtedness given default occurred over a year ago. So in our view, nothing raises a genuine issue requiring trial, which is why we submit this as an appropriate case for a summary judgment. Those are my submissions, Your Honor. I can also provide cost submissions if appropriate.
So there's no penalty charges, it's just interest running?
That is correct. The 3 months interest charge, as Your Honor can see, was waived.
Yeah, okay. All right. Ms. Henry, do you have any submissions?
Mr. Adjudicator, I am Chief Micheal. I am going to be presenting on the matter on behalf of Federica Henry and Federica.
On what basis? Are you a lawyer?
Pursuant to Section 26, 1 subsection 5 of the Law Society Act, it gives the provisions for a non-lawyer to appear on matters
with leave of the court. So you'd have to get leave of the court first, sir.
I have already filed it on the record on the court. It's on case line as well. It's a power of attorney / consent, and that's also an affirm affidavit.
Oh goodness. Ms. Henry, could I see you on camera, please?
I am here.
Okay. Are you consenting to having the gentleman beside you to give submissions on your behalf?
I fully consent.
Do you appreciate what's at stake in this proceeding?
What do you mean?
What the issues are, what the order being sought is.
Yep.
You're not speaking.
Can you give me that in your own words?
I am not speaking on the matter. I asked Chief Micheal to speak on my behalf.
Understood, but this affects you. It doesn't affect Chief Micheal. So before I consider whether he can speak on your behalf, I want to know if you appreciate what's at stake on this motion?
I do, yes.
Tell me in your own words.
I do appreciate, and I would like Chief Micheal to speak on my behalf.
What will happen if the Bank of Montreal is successful?
What do you mean?
This is a motion for summary judgment, which
Okay,
means there'll be no more court attendances. This is it.
okay.
Is in effect the final outcome at
I-
trial.
I
Sorry,
beg to
final
differ.
outcome Sir, I'm not speaking to you.
Please, okay, let's get the record straight before we get started. So first and foremost, we're going to establish a respectable environment here. So I would ask you, Ms. Adjudicator, don't refer to me as a sir. I refer to me as Chief Micheal. That's my title. There's an affidavit filed pursuant to Rule 20.02, subsection 2, invoking for the matter to go to trial. So this is not the final.
Thank you, Chief Micheal.
So if you look at the court record and case line, you can see the documents. I'm not sure if you have take a look at what was filed from the respondent standpoint.
The purpose of my questions, Chief Micheal, was to establish whether the defendant understands the nature and consequences of having you speak on her behalf. And that's a question that only she can answer.
I think she already answered. I will allow her to answer again.
I answered. I said, yes, I'm aware.
Okay, so we'll go from there. You have 10 minutes, Chief Micheal.
10 minutes. All right, so what I have in place here is an affidavit. I'm not sure, can you confirm for me that you can see what I'm talking about on your filing, on the record?
If you give me the case center number, I will have it right here on my screen.
I have to give you the case center number?
Yes, just as counsel for the bank did.
Well, wouldn't it be the same information there and the same? I am not familiar with Case Center. I have the documents filed through the court. They uploaded it to Case Center on my behalf. So I would believe that this is the Superior Court of Ontario, not Case Center, correct? Are we in the Superior Court of Ontario?
Please say that again.
It's just a general question, and with all due respect, it's not to be no form of disrespect, but are we in the Superior Court of Ontario? Is this a Zoom link from the Superior Court of Ontario?
Yes.
So why am I being referred to go back to Case Center so you can see the documents that I filed with the court? That if you ask me, it's kind of, pushing me down the rabbit hole of procedural unfairness here.
It's to assist me as the trier of fact, because there's over 1,000 pages of documents, and I can only look at one page at a time.
So in order for you to look at what was filed, you can only go to Case Center on my behalf.
If you wish me to focus on a page, which I thought you were doing, then as a good advocate, you will take me to that page so I can follow what you're saying to me on the written materials. If you would rather just speak without me following you in writing, we can do that too.
Yes, yes, we can do that. However, as you stated there, as a good advocate and also a good adjudicator, I would believe that the matter would be read prior to the hearing. However, we don't have to go there. I can get started.
Thank you.
So first I'm gonna do the respond to the motion. Once again, I'm not sure if you can see it, but I have conclusive evidence that all material that I have here is filed with the court seal. So denial of jurisdiction. The respondent continued to challenge the jurisdiction of the court based on sovereignty, indigenous rights, customary law, and absence of valid consent to submit to corporate statutory regimes. As an indigenous woman, the respondent does not operate in commerce and is not subject to jurisdiction of financial institution or statutory tribunals absent informed bilateral consent and full disclosure of rights and consequence. The plaintiff relies on unsigned or unverified mortgage instrument that appear to resemble a bill of exchange or a promissory note, subject to a bill of exchange act. And the instrument was not presented for inspection nor proven to remain in its original form and lawful possession. Upon transfer of the property from the seller, the buyer full consideration was rendered and paid in full. The deed transfer registered number as BR188492 complete the transaction. The extinguish my apologies. This extinguish the debt as per equitable and common law principle. Therefore, the consideration requirement under contract law was satisfied upon the covenants of the title. The plaintiff mortgage claim arise after the fact relying on a contract formed through asymmetric information, non-disclosure, and deceptive practices that misled the respondent into unknowingly conveying tenure and lawful title to the lender. At no point was equal consideration provided by the plaintiff. The mortgage was not supported by real capital or funds, but it was instead monetized from the respondent's owner's promissory signature consistent. Apologies.
Take your time.
Consistent with fraudulent inducement theory as seen in First Nation Bank of Montonomori versus Jerome Delhi, 1968, where the court ruled that the bank cannot lend or create money without consideration. Under contract law, valid consideration required that both parties give something of legal value. The plaintiff provided tangible. The plaintiff provided tangible value for lawful currency. Only bookkeeping entry leveraging the respondent's credit as collateral. But with that being said, I'm not going to go further on the respondent. Let's go into the affidavit because I find myself speaking on the matter and we're not going to have all the evidence that we're requesting to bring forth here today.
What's the legal test for today?
Pardon me?
What's the legal test for today? What do you say is the legal test?
The legal test?
On a motion for summary judgment, which is what the plaintiff is bringing, what do you say is the legal test?
Well, I want to know what you mean by a legal test because can you break it down for me?
No, I can't. I'm the judge. I'm the impartial adjudicator. If you're not giving me a legal test to apply,
I am.
And what is that legal test?
So it would be the affidavit of Frederica Henry.
An affidavit is evidence.
Yes. Pursuant to Rule 20.02 2, subsection 2 of the Rule of Civil Proceeding.
Which is?
I can go ahead and read it. So on behalf of Frederica Henry, and I quote, I am the respondent in this matter and have personal knowledge of the facts stated herein, except where indicated to be based on information and belief.
So you're reading the affidavit. I thought you were going to read Rule 20, which is the rule for summary judgment under the rules of procedure.
I would believe that you would have known what that is as the adjudicator.
I do.
As a good adjudicator.
I do, sir. The question is that the legal test upon which you are relying?
Yes, so that which is an firm affidavit. We're relying on that.
Very good. Please proceed.
All right. So on behalf of the respondent, I make this affidavit in position to the plaintiff's motion for summary judgment and in support of the position that there is existing genuine issue requiring a trial pursuant to Rule 20.02, subsection 2, and 20.04 of the Rule of Civil Procedure. The property transfer and full consideration on or about October 13, 2022, I became the registered owner of the property, known municipally as 250 can you pronounce that? Tandaniga Drive, Southampton, Ontario. The full consideration for this property was rendered and acknowledged by the transfer as evidence by the registered transfer instrument number BR 188492. At the time of the transfer, all obligation from the buyer to seller were satisfied in full. Therefore, the equitable obligation was discharged. Any subsequent mortgage contract with the plaintiff, Bank of Montreal, was entered into after full consideration had already been rendered and therefore lacks lawful foundation unless accompanied by new and sufficient consideration which was not provided. So now let's go into the mortgage definition. So the definition of mortgage and lack of informed consent. So according to Black's Law Dictionary, 4th edition, mortgage is a conveyance of title to property that given a security for the payment of the debt or the performance of a duty and becomes void upon such payment or performance. So on behalf of the respondent, I was never made aware that enter into the mortgage contract involve conveying my rights and tenure to the plaintiff, nor that the mortgage allowed for the plaintiff to exercise dominion over my property in the event of an alleged default. At no time I was provided with full disclosure, independent legal advice, or any opportunity for informed negotiation. The term were imposed through a standard form contract that I did not comprehend or meant to forfeiture of my property rights. As such, the contract was entered under fraud, in inducement, unconscionability, and lack of informed consent, and is null and void ab initio, that's Latin, or at minimum valuable in equity. Failure of consideration and deceptive inducement. The plaintiff did not provide equal or lawful consideration in exchange for my conveyance of my property. Rather than lending actual capital, the plaintiff monetized my signed promissory note and create credit ex nihilo through a ledger entry, not legal tender, not backed by tangible value, and not disclosed to me as much. Under equitable contract law, a valid contract must include lawful and mutual consideration. The plaintiff provided none of the above. Therefore, the alleged debt is unenforceable. Securitization and transfer of interest. On behalf of the respondent, I believe and have reasonable grounds to assert that the mortgage was securitized, pooled, and sold as part of a mortgage-backed security. The plaintiff has failed to disclose whether the underlying debt was sold, transferred, or assigned, settled via insurance, third-party insurance, or derivative financial instrument, or other derivative financial instrument, held in trust for third-party investors or certificate holders. If securitized, the plaintiff may no longer possess legal standing to enforce, which raises genuine triable issue. Third-party insurance, double recovery. The plaintiff has failed to produce any documentation confirming whether the mortgage default insurance was in place. Any payout has been received from, if any payout has been received from CM, apologies. Yeah, we got to turn these phones off. All right, apologies, I know the phones are coming. All right, let me just find back where I was here.
CMC?
Yeah.
Insurance.
Yeah, or other insurance. The value of such indemnification has been credited to the alleged debt. Without such disclosure, there is a serious risk of double recovery in which the plaintiff has already been compensated but continues to pursue enforcement. Indigenous rights and constitutional protection. On behalf of the respondent, I am an Indigenous woman with ancestral connection to the land I lawfully occupy. I assert my rights under Section 35 of the Constitution Act of 1867 to 1982, the United Nations Declaration on the Rights of Indigenous People, Article 26 and 28, and the Truth and Reconciliation Commission Calls to Action 94. The plaintiff had made no effort to consult, recognize, or accommodate my rights as an Indigenous individual. This enforcement action is a form of cultural and economic dispossession. Improper legal authority and ultra-virus actions. The plaintiff legal representative have not provided proof of a valid contract or of agency, power of attorney, trust deed, or legal assignment. I assert that the representative or acting as third-party interloper and have no standing under Rule 7.02 of the Law Society Act. Triable issue requiring a full hearing, I respectfully submit that the following genuine issues require a trial. Whether the mortgage is valid and enforceable. whether the plaintiff retained standing to enforce, whether the consideration was fully provided, whether third-party insurance or securitization has discharged the debt, whether my indigenous rights have been violated, whether summary judgment would violate natural justice in accordance with Section 65, subsection 1 of the Judges Act. The issue involve complex constitutional, contractual, and equity law consideration that cannot be resolved without a full hearing. The relief, I request that this honorable court dismiss the plaintiff motion for summary judgment, stay all enforcement action, schedule the matter for a full trial, and also full disclosure and document production shall be summoned from the plaintiff. Award cost and a substantial indemnity basis due to depressive conduct, and that would be my submission in accordance with Rule 20.02, subsection 2.
Thank you. Any reply, counsel? Oh, you're on mute.
Pardon me. Only to confirm that no amounts were received from the mortgagor to the bank since default. So I'm unsure of the basis for what Chief Micheal is saying. And we do continue to submit this as an appropriate case for summary judgment.
Okay, thank you. If successful, and what amount of costs are you seeking on today's motion?
I uploaded a cost outline. This is at master A110. We're seeking costs on a substantial indemnity basis, and we're requesting $9,773.09. The mortgage provides that the defendant agreed to pay the bank's legals on a solicitor-client basis, and this amount includes 2 triage court appearances, as well as preparing a reply and defense to a counterclaim, which was because a counterclaim was referenced in the statement of defense, so that added time. And further, given the straightforward nature of this matter, it was assigned to myself as a junior associate. This was done in an effort to minimize costs. So it's for these reasons why we believe our costs we are seeking to be reasonable.
Thank you. Chief Micheals, if you're successful, what costs are you seeking?
I won't be seeking any costs for today because we will do so at the trial venue because we're not looking for a conclusion here today. I do get it that this is the proceedings, but at this point in time, we're not seeking any costs. We will reserve that for a trial venue based on the outcome of that. However, also I can see that the representative for the plaintiff is seeking cost as well, but I can assure you, my honor, that she has not done any work for the respondent. So that would be highly inappropriate that she's requesting cost, because I can guarantee you she's not here today for free, unless she can affirm otherwise that she's here as an advocate donating her time. I don't think that's the case. So that would be highly inappropriate for once to be, and it's disturbing if you ask me.
Thank you. Counsel, would you please email in a Word form the draft judgment that you're seeking today? If you could send that to my registrar. Makes it
Yes,
easier
Your
to
Honor.
work with. I don't see a draft judgment from the respondent. Let me just double check.
Well, we wouldn't be putting together a draft judgment because we're Just to reassure you, My Honor, I am operating within the rules of the civil procedure here. So everything that I bring forth today was within the lines of the game. So I expect you to officiate the match in accordance. I yield.
All right, very good. That'll conclude today's hearings, and you'll have a decision in writing shortly.
Thank you, Your Honor. I do not have Madam Registrar's email, so if that could be in the chat or some other
Yes,
avenue.
Mr. Registrar, could you please put that into the chat or on your tile?
Yes, Your Honor, doing that now.
Thank you very much.
All right, that concludes the first two matters of the day. So we'll call the morning recess. When I resume at 11:30, we'll be speaking to Museri versus Museri.
So, Your Honor, just to conclude, I will be hearing from the court, the
Yes,
event center.
I'll do my decision in writing, and you should have that by end of the day.
Okay, gratitude.